Hi again, welcome back. Attorney Steve Vonderen. We are talking in this video about internet stalking. We're going to be talking about a California law, and this deals with internet stalking when you have that person that is stalking either your business or your person, and they're just nagging you. They won't go away. Maybe they're saying threatening things. Maybe they're saying obscene things. This is good information for parents and their kids to go over, crossing the line from free speech into potentially civil liability. Okay, so again, this is Law Office of Steve Vonderen. We're licensed to practice law in California and Arizona. Here's our disclaimer. General legal information only, not legal advice or a substitute for legal advice, advertisement and communication, so forth. Okay, so you have that here. This is the tort of stalking. A tort is essentially a civil wrong committed by one person against another for which the law will provide a remedy. Here we have California Civil Code section 1708.7. This is the tort of stalking. Here is what's required. Okay, again, this is general legal information only. The case law may add or detract from some of this, and so forth and so on. But a person is liable for the tort of stalking when a plaintiff proves all of the following. Okay, all of the following. So you're going to see there's going to be three things that need to be shown here. Okay, one, defendant engaged in a pattern of conduct. There's our keyword, pattern of conduct, the intent of which was to follow, alarm, place under surveillance, or harass the plaintiff. So those are some of your keywords there. Pattern of conduct, number one. Intent, number two. Follow, alarm, place under surveillance, or harass. So that's all part of the prong number one. Okay. In order to establish this element, the plaintiff shall be required to support his or her allegations with independent corroborating evidence. So this is where you're good having the printouts of everything that happened. Sometimes for businesses, it's complaint board. Sometimes it's a Yelp review. Sometimes maybe it's a Google review. But anyway, you want to have some kind of independent corroborating evidence, witnesses, those kinds of things. So there's element number one, pattern of conduct intending to do those items. Number two, as a result of that pattern of conduct, either of the following occurred. So this is an A or a B. Okay, this is element number two. As a result of that pattern of conduct, either of the following occurred. A, the plaintiff reasonably feared for his or her safety or the safety of an immediate family member. So there is a reasonable fear for your safety or the safety of an immediate family member. Okay, and we have some definitions there. I'm not going to go over that. I posted this article on freespeech.attorney. If you want to go check it out and read the definitions, freespeech.attorney. Okay, here's the B. The plaintiff suffered substantial emotional distress, and the pattern of conduct would cause a reasonable person to suffer substantial emotional distress. Okay, so it's either the A or the B, and I'll let you go back and look up the document if you want, but that's it. And item number three, the third prong a plaintiff has to show is one of the following. A, that defendant, as part of the pattern or conduct specified in paragraph 1, made a credible threat. So there has to be a credible threat with either, one, the intent to place plaintiff in a reasonable fear for his or her safety or the safety of an immediate family member. So there needs to be that intent to place the plaintiff in reasonable fear for safety, or two, the reckless disregard. That's a little bit less than intent. So intent may be considered a higher level, reckless disregard a little bit easier to satisfy. Okay, so it's above a negligence standard, it's reckless. So essentially you have negligence, reckless, intentional. Okay, so a reckless standard will get you there. Reckless disregard for the safety of the plaintiff or that of an immediate family member. In addition, the plaintiff must have on at least one occasion clearly and definitively demanded that the defendant cease and abate his or her pattern of conduct, and the defendant persisted in his or her pattern of conduct unless exigent circumstances make the plaintiff's communication of the demand impractical or unsafe. So this is really your demand requirement. So somebody is doing this to you. They're stalking you. They're following you. They're making you alarmed. They're doing it intentionally, recklessly. They intend to cause fear in you and or your family members, put them on notice. This is a section that says stop doing what you're doing. Okay, so in order to maybe go to the next level and think about, hey, are we going to file a suit? Are there damages here? This is a section that talks about cease and desist. Okay, don't forget that one. B, the defendant violated a restraining order is another way to get there. And then you have your definition section. So that's kind of the law in a nutshell. I'll go over just a couple of these definitions just for your edification. Pattern of conduct means conduct composed of a series of acts over a period of time, however short, evidencing a continuity of purpose, okay? So they're out to do something. Very important here. Constitutionally, I'm going to highlight this. Constitutionally protected activity is not included within the meaning of pattern of conduct. So bear this in mind. This is very important. If you get into this area of law, you have free speech coming into play. People are allowed to say things. They're allowed to express opinions. They're allowed to say factual things. So just bear in mind, because what you don't want is to get caught up into this area and think you're going to file a lawsuit and then somebody's filing an anti-SLAPP against you. An anti-SLAPP would be somebody saying, this person's suing me because I'm exercising my free speech rights. And this statute specifically, the Civil Code, talks about the free speech, constitutionally protected activity, First Amendment. Okay, so make sure this is where you may need to get a lawyer involved to evaluate your situation and kind of decide, am I gonna get clipped on free speech? Is it worth bringing? Should I just do the cease and desist letter? Those kinds of things, okay? Credible threat, the definition, what does that mean? Means a verbal or written threat, including that communicated by means of an electronic communication device, email, or a threat implied by a pattern of conduct, including but not limited to acts in which a defendant directly, indirectly, or through third parties by any action, method, device, or means follows, harasses, monitors, surveils, threatens, or interferes with, or damages the plaintiff's property, or a combination of verbal, written, or electronically communicated statements and conducts, blah, blah, blah. I'm going to stop there. You can read the rest of that. You got your some of your other definitions. You have follows. What does it mean to follow? I'll go down slowly. If you want to pause the video, you can do that and come and look. Or just go to my website, freespeech.attorney. Okay, so that may be it. We have harass. I'll go over that real quick. Means a knowing and willful course of conduct directed at a specific person which seriously alarms, annoys, torments, or terrorizes the person and which serves no legitimate purpose. Okay, so these are things that lawyers argue about, these words, what do they mean, so forth and so on, okay? Here's place under surveillance, and what else? A couple more things. But again, substantial emotional distress, we talked about this, shall not be construed to have the same meaning as severe emotional distress, which is a word that we use in intentional infliction of emotional distress. Short, we call it IIED. So substantial emotional distress is not the same as severe. Usually it's a very high bar when you're trying to claim emotional distress for intentional infliction of emotional distress. This statute is saying it's not the same meaning. Rather, it requires, I'll highlight this, it requires an evaluation of the totality of the circumstances to determine whether the defendant reasonably caused the plaintiff substantial fear, anxiety, or emotional torment. So this is one of those statutes where the courts may look at this and say, sorry, hurt feelings just isn't going to get you there. Being angry isn't going to get you there. We need some substantial emotional distress, okay? Something that rises to that level. Okay, here it is. Here's your damages section. A person who is liable, who commits the tort of stalking upon another, is liable to that person for damages, including but not limited to general damages, special damages, and punitive damages, pursuant to Section 3294. What's the difference? General damages, those are damages that people generally suffer, pain and suffering, those kinds of things. Loss of consortium. Special damages would be any out-of-pocket losses, specific losses that were suffered. And punitive damages That's a number that, let's say, for example, a jury, if you went to a jury trial, a jury may fix a number and say that's $1 million in punitive damages designed to punish and deter future conduct. So those are the different kinds of damages that are available, and so that's about it. The rights and remedies are provided in this section are cumulative, and in addition to any other rights and remedies provided by law, so you can sue for different things. For example, say you also were an elder and somebody was stalking you as an elder, and ripped you off of some money or property. Then you may also have an elder abuse claim. So one doesn't preclude the other. That's about it, okay? So that is a quick, rough, dirty overview. Again, this section shall not be construed to impair any constitutional protected activity, including but not limited to speech, protest, assembly. So again, be very careful with that First Amendment. The courts will protect that and take a look at that. Again, if you need more information, free speech attorney. If you need some help with cease and desist levers, mediation, arbitration, litigation, give us a call. You can find out more information at freespeech.attorney. Yes, I went for one of those exotic domain names. This is Attorney Steve. I hope this has been helpful for you. If so, feel free to share this video on your social media networks. And don't forget to subscribe so you can get some more of these great videos. Okay, Attorney Steve out. Have a great day. We'll talk again.